thank you everyone for coming to Sheffield and being part of this day. It's been a wonderful, I think, example of how health and social care can work together in the common good to kind of help patients, and hope this is another example of how end-of-life care is a great example of where we can all work together very effectively. My journey with deprivation of liberty actually started as a junior consultant when a colleague of mine suggested I might update our MCA DoLS policy, which you can imagine I can't tell you how grateful I am for that experience. But it was really quite a fantastic journey, and it really has massively increased my understanding in a way as a consultant I don't think I otherwise would have really have been exposed to. Just for my colleague who is in the room, the policy is almost finished. We're faced with these headlines, and these are a few. This is just a couple of headlines which we encountered. One from the Telegraph and Argus, which I hadn't received until I've never read this until I got this, which is a local paper. I think belongs to Bradford, I think, but you can tell me. Yeah, I've got some nods there. And this one's from the Independent. And I think what they all do is they all highlight the challenges. This mainly relates to what happens as a consequence of MCA DoLS and the fact that we have to, that they are considered a death in state detention, and the impact of that on families and on their experience. What I'm going to try and do is just very briefly just consider some of the challenges in MCA DoLS and really recap on our experience and really what some of us have been describing in this room, and also to talk to some potential supportive tools and solutions to address this, and also reference some of the fantastic work going up in the Northeast around deciding right, which I think makes it a good clinical tool for patients to use, for clinicians to use. And we're just sorry that Claude Reynard, who is a major proponent of that, couldn't be here with us today to talk about that in more detail. So I'll do my best. Anyone from Newcastle and the Northeast, please bear with me. Some of the challenges that we face really around MCA DoLS, I think Neil put it very well earlier on from the Department of Health when he was talking about the laudable aims of the Mental Capacity Act. And I think the challenges really arise for us when we're, as professionals, trying to make and support patients with patients who don't have capacity about fundamental issues that affect them in their lives. And whilst at the same time the challenges of trying to support people through processes like MCA DoLS are numerous, I think the aims of ensuring that we have auditable, overseen, well-developed care where there's oversight for patients who lack capacity is I think something that none of us can deny is an important thing that is accessible for people. I think one of the major challenges that we found, and has been described many times today, is simply the lack of a statutory definition of what is deprivation of liberty. And what that creates is a requirement for us all to interpret this in our own way according to the standards, vague as they are. And that's the challenges. I think many of us are quite risk averse, and so what we don't want to do is to interpret things in the wrong way and find ourselves caught up in facing a challenge on that. But I think the absence of robust case law kind of leaves it open to our interpretation. And until such a time as we are challenged in case law around things around end of life, I would suggest if we are collegiate in how we make these decisions and work together, then I think that's probably the best we can do at this moment in time. But I will look to my legal colleagues to give me the nod to see whether that feels like a correct approach. Most of our problems in the around end of life, I think, really relate since the development of the acid test. And I think, as Neil also alluded to, the number of applications for authorizations of deprivation of liberty were very low previously. And following the acid test in March 2014, there was a sudden explosion, principally around the challenges interpreting continuous control and supervision, and also interpretation around freedom to leave. And what Cheshire West and the rulings in Cheshire West and other cases did provide for us was this situation where we understood that DoLS no longer considered a number of points. I won't necessarily read these all out. All of the slides will be available on our website later on, and on the, I hope, the Hospice UK website later on. So that will be available to access. But I think some of the key things that present us particular challenges around end-of-life care, I think we described the situation, well, a patient's dying, so why should, if they're dying normally, why should that present this problem? The problem is the interpretation of the law in a legal sense, and this line, appropriateness or relative normality of treatment, is irrelevant. So it doesn't really matter if it's normal that everyone who's in a hospice is dying, and that it's normal to put up a syringe driver to administer medication to keep them comfortable in a state of hyperactive delirium. That doesn't matter. The fact is that we have put up a syringe driver that gives sedative medication is what amounts to the deprivation of liberty, depending on how you interpret it. And so as professionals, it's not really up to us to make that decision. That is the law, and it's challenging, I think, for even Tim and Neil in the Department of Health to change that. And I think that's one of the challenges that I've come to appreciate as we've proceeded through this work. I guess the major challenges, as we're describing today for us, obviously around end-of-life care is what we're here to discuss, but equally there are challenges presented in the literal interpretation of law in intensive care units. And it's all about literal interpretation, and that's part of the problem. These are just some links to the pages that I showed you, the Independent and the Telegraph and Argus. And that really talks to the impact of this on every person, and potentially on increasing numbers of people as dementia increases if this legislation does not change. What I think we have been grateful for is the Law Society's intervention at the behest of the Department of Health. And that guidance has provided us with a bit of breathing space and a bit of a stopgap, really. And it's that guidance that enabled Neil Fry and the Department of Health to issue the letter in January, which put forward a number of very sensible propositions, which gave us an opportunity to modify how we interpret the law in a way that was meaningful and less disruptive within the bounds of the law. Obviously, that was commissioned by the Department of Health, and it was an update to Chapter 2, I think, of the Mental Capacity Code of Practice, which related specifically to DoLS, but it isn't a legal document necessarily. It doesn't have the same statutory status. What I would say is that that we can say that the Department of Health say that this is okay to follow. So broadly, that means it's all right for us. But I think if we look back in history, there have been cases where there's been the cry that I was just following orders, and that doesn't necessarily stand the test of legal challenge. What I think is really key in some of the guidance that we saw and the recommendations that came out of that Law Society guidance, and it's also important for those of us who are not familiar, as I wasn't, the Law Society and the Law Commission are very different bodies. They are not the same. So it's easy if you don't mix in legal parlance to understand that, but they are very different. But what the Law Society's guidance allowed Department of Health to note was that palliative care, as it related to in the document, related to people within the last few weeks of life. I would refer you to Jonathan Ellis's talk earlier on and the challenges around interpretation of the terminology. And I think I was speaking with Ros, we were speaking with Ros in the break, Ros Taylor, and I think if we look at the scheme as it stands, there's the terminology around supportive care. Well, in medicine, when we say supportive care, we mean something. So there's lots of challenges in making sure that we're using common language that we share, which are things that are important for us to take forward. I think that really, the other key issues to come out of this is if a person has capacity to consent to arrangement and does consent, there is no deprivation of liberty. It sounds really obvious, but in legal terms, it's important to say it out loud. But what's really useful to know is that if they make that they give that consent in advance, when they lose capacity, that consent at end of life still stands. And this is why it's so key for us to take this as an opportunity to push forward the value of advanced care planning. I appreciate in some of the breakout group presentations, which were fantastic, and thank you for those, that there was concern really about when advanced care planning can be valid. But I think advanced care planning, from my perspective, is a continual process. It's not static, and we will see that it will happen. So I don't think we could or should necessarily suggest that advanced care planning done a year ago is the advanced care planning we should be referring to. I think what we need to recognise is that when someone is readmitted to hospital, who's potentially end of life or on a palliative care register, if we have proper coordination, that we can be ensuring that we have processes in our hospices, in our acute hospitals, that enable us to take note of that and update it. But that's a process and operational issue for organisations, not, I would argue, a question for the law. But that would be my interpretation of it. I think that obviously within that issue around advanced care planning, it talks to there being important exceptions, and where the circumstances around which that consent have changed are very different from the original consent, that doesn't apply. I think that's really logical. And I don't think as a clinician, if you're looking at an advanced care plan, although it's difficult for us looking after the dying people to have to follow these rules, I think the importance of ensuring that we're following the principles of the Mental Capacity Act probably should outweigh the challenges that we face as clinicians. And I think that's not something that that comes from my natural place of being as a clinician. That's something that I have learned from my interaction with social care colleagues and social work colleagues who feel very strongly about this and actually really genuinely see the value of this. And I think it's important that we all engage in that. I suppose the other really valuable things is unconsciousness in itself is not considered a mental disorder. And the key thing is that if someone's just flat and doesn't exhibit signs or hasn't in the run-up exhibited signs of a mental disorder, those are the peaceful, comfortable patients who are dying, who aren't on a syringe driver, who aren't on anything. We don't have to think about it. That does not constitute deprivation of liberty. And I think what I've seen, what I've been doing in my work and what we've been doing in our work is seeing this great big hole of patients to whom deprivation of liberty might apply, and then being able to say, well, I can take this wedge off, because this wedge, the letter from the Department of Health says it doesn't apply to them, and so the hole gets smaller. And what we may be left with, if we can take enough pieces off of that big hole of patients in end of life for whom deprivation of liberty may be applicable, we might be left with a small, manageable population in whom the safeguards are truly appropriate. But it's just about reflecting on that. I think the other thing is that an individual who's unconscious, who does not have a mental disorder, will not be eligible for a deprivation of liberty. And a thing that I also found fascinating, which I found in the Law Society document, was that the Strasbourg case law, so the European Court of Human Rights, seemed to suggest that a deprivation of liberty must not last for a non-negligible period of time. I think what is a non-negligible period of time is subject to debate, and it's not really very clear at all what that means. What was really useful in the Law Society guidance, it offered a set of cases where there were some examples around which you might base your thoughts. And what I think is useful is if we are collegiate in our localities, we can probably decide in ourselves what constitutes a non-negligible period of time, and subject to case law or challenge, then we're kind of all right. It's kind of, that's my interpretation of it, but you know, I would say that's certainly my vision of the world. We are left with a number of contentious scenarios, and one of them is hyperactive delirium. I've got to thank Claude Reynard for that term. Normally I used to say terminal agitation. I've changed my use of that phrase, but I would say hyperactive delirium, really in the actively dying, is how I would describe terminal agitation, which was probably a colloquial term that we use in palliative care for that condition. And hyperactive delirium at that phase does present particular challenges, because if you follow the letter of the law, it probably does, to a certain extent, constitute a deprivation of liberty. You have a patient who is often does not have capacity to make a decision, and that you are chemically restraining them with benzodiazepines, major tranquilizers, to keep them comfortable and allow them to die peacefully. The challenge for us in practical terms is if we apply that literally to every single patient who's receiving palliative care in hospice or acute hospital settings. I mean, in Sheffield alone, if we have 5,000 patients dying each year, about 2,600 of those dying in the acute hospital setting, a significant proportion, even if we say 1,000 of those patients are dying under those circumstances, that would be 1,000 more cases to go to the coroner and to be processed by the local health authority. And that just isn't logical to me. And so we're left in a challenging situation where we have to negotiate our way through this, and it's all about this literal interpretation. The other issue around interpretation is around the freedom to leave, and it's something else that we've discussed again over the course of today. What I really like in at risk of being sycophantic in the new scheme is the proposal to slightly modify the terminology around the acid test, where it's kind of talking about, not only about the patient is unable to leave either because of disease or because of medication, but they would not be able to leave if the family were able to choose to take them out. Because actually, from an interpretation perspective, my view is that actually, if I am trying to deliver the least restrictive care, whether it's a wise decision or not, in the view of best interest, I would be quite happy if a family would choose to take the patient home to allow them to die. I have no objection to that. And so, to my mind, in many of those cases, it takes off another big wedge of that hole. Because actually, I wouldn't be obstructing them taking someone home if they choose to die. And if I'm not quite so paternalistic about the risks of someone dying in an ambulance, because the least restrictive care is about them dying on the way to their own environment where they're cared for, then I think that presents us with an opportunity to be more relaxed. But it's a difficult thing for me as a palliative care consultant who has very much viewed the decision to move and not to move as my sacrosanct clinical right. It's a difficult thing for me to relinquish, because actually, how do we make a judgment about best interest? But I think that's a professional judgment for us in specialist palliative care, and generalist palliative care and medicine, nursing, for us to discuss what is right. I think that if we can interpret differently, it may actually free us a bit more. So how do we address the challenge? Well, I think when I was speaking with a colleague, we spoke in terminology about the challenges in interpreting it, and phrases like pragmatism and being a zealot kind of came up, and I thought that's quite hard language to use, and I thought a better language to use is about being hawks and doves. And really, I think as we try to navigate our way through this, if we think about the shape of the new NHS, where very little is centralised, and I over time have heard BWE talk about this many times, that there will be very few central edicts coming from above, and that actually we need to have a better kind of form of localism that allows us to manage things. That if we can think about really understanding whether we're amongst hawks or doves, that will help us figure out where we sit. And it will help us make a judgment as to how literally and how relaxed we can be about interpretation of the law. Because if locally no one has a problem, why would we have a problem? If locally that there is a very strict and literal interpretation, we may not like it until the law is revised, but then that's the rules that we need to follow. And I think it's about being collegiate. It's about local collaboration. I think that's what I believe hospice movement is about, is us being collaborative with partners around us. I think that's what good end-of-life care, whether it be in hospice, acute hospital, in community, is about us interacting with professionals across a range of services and organisations. So if we can collaborate with our supervisory bodies, with our coroners, sorry, I hope I don't get points off there, Chris. And with our managing authorities and be clear, then I think that it will go some way to managing the anxiety, certainly that I feel as the responsible medical director in trying to make judgments in this case. But I'll be very interested to hear what everyone's thoughts are. Other things that can help us or assist us, for example, are the ADAS task force tool that a lot of our colleagues in social services will look to help them guide them as to how they prioritize the overwhelming number of cases in terms of deprivation of liberty safeguards that they face. And in that tool, ADAS, for those of us who don't know, and I didn't know before I started on this journey, I think it's the Association of Directors of Adult Social Services, and I'm seeing nods, so that's good, I've got it right. And what that suggests, really, is that, that where it's not appropriate, that the Adult Social Services Department, in the overwhelming list of cases that they face, they would not necessarily give high priority to cases in end-of-life cases or intensive care cases where the application of the safeguards in the situation wouldn't be a benefit. So they're not rushing to stress about it, or the ADAS says that they don't need to rush to be overly anxious about it, which potentially, in addition to the letter from the Department of Health, it should give us some grounds to feel a little bit more relaxed if we are collegiate with our localities in how we address this issue. I think that the other thing I would say is other ways to deal with this are producing a robust Mental Capacity Act policy using DoLS and best interest. We've had several iterations of our Mental Capacity Act policy, I can reassure you, Vandana. We have got, we've actually got to the point now for us where we've actually had it legally checked by a healthcare lawyer to provide us with the confidence that it will stand up to scrutiny. And, you know, we were in a position where we took that decision, but is there a reason why hospices couldn't band together to make these kind of tests, to create policies that are supportive of us? Why wouldn't we be doing that? Is there a reason why we couldn't be working, if we're not working as groups of hospices, why we couldn't be working in localities to make sure that there's parity between us and making things straightforward? The other thing is that this is a real opportunity to bang the drum around advanced care planning. And within our acute hospital settings, if advanced care planning doesn't have priority of place, if there was ever a lever, this is one. And it's about trying to actually embed that in our management of care of our patients. And whether that's referring to a little used Royal College of Physicians ward round checklist, which directly refers trust to develop recognition of advanced care planning in their active ward rounds. All of these things are things that we've been there before, but we've seen very little real action, but it's probably because there aren't the levers to make trust respond appropriately. In the case of the actively dying, really as ways of trying to manage this, there are other things that you can consider. You know, does hyperactive delirium in the actively dying constitute an emergency treatment? And if there isn't a particular issue about period of time in those circumstances, does that mean that it should come under DoLS or shouldn't it? It's open to interpretation. It's a real question. But obviously, if someone stabilizes for a considerable period of time where you're treating them for hyperactive delirium, then it may be that we have to be open-minded and consider it. And these are questions that I think it's useful for us to develop an agreement on locally. I think that the other thing is that, as has been mentioned already today, dying occurs in a range of settings, and we must remember that where dying occurs in the acute setting, the rules that apply in hospice will also apply there, but equally will also apply in community. There is an argument that we should be referring more cases to the Court of Protection if actually the simple language around treatment is true for our hospice at home services, for example. But again, we don't want to collapse the system. There's something about being pragmatic that I think is important. For those who are in the acute setting, it's just worth noting that the Intensive Care Society have issued guidance around intensive care issues that I think in many instances parallel what we've been talking about in end-of-life care. And that in relation to referrals to to the coroner, I think there is a question that if a standard authorisation has been made but hasn't been authorised by your local authority, by your supervisory body, is that patient actually under a DoLS? I don't know. It's a question, but it's a question that isn't been conclusively answered. I think the solution to addressing some of those headlines that we saw right at the start is communicate any referral requirement to the coroner early. I still feel uncomfortable, with the greatest respect, and we have a very, very sensitive, very good coroner service in Sheffield and South Yorkshire. I still feel anxious about having to speak to patients who have mesothelioma, about having to send their loved ones for a coroner's inquest. But actually, if I'm honest, that's probably more my problem as a clinician than the families and relatives, and many people want answers. And I think that perhaps, may be controversial, that perhaps that we as a cohort maybe need to look into ourselves about what we're comfortable about, and if there's a requirement for us to address this within the population and be able to have brave conversations to protect the vulnerable few, then maybe that's something that we need to consider as a professional cohort. Just a question. But in any of this, as with everything that we do in palliative and end-of-life care, the way to manage challenging situations is communicate, and communicate well, and communicate early. Why should it be any different? Okay, so just very quickly, because I'll have about 2 minutes or a minute left. Really, the key tools that we can use to help us in this are develop a good policy. I think I've spoken about that. Consider a legal review, or club together, because actually it's worthwhile. It will make you feel more confident. But then also for clinicians on a day-to-day basis, consider deciding right as a tool to help you operationally out on the floor. Now, deciding right is a tool which was developed up in the northeast, so just another example of good work coming out of the north of England. And you know, I think it's quite a robust decision aid that can help you make decisions and really consider a great deal of a great number of issues around the dying phase of patients. It actually comes on an app which is free on Google Play and on the Apple Store. And for me, at the moment, it doesn't contain the DoLS framework on it. But soon, once it's been approved through a legal firm called Hempsons in London. It's sitting on the desk in the Department of Health waiting for the legal team there to give it the app the final sign-off. But it actually gives you a very good step-by-step guide through to determine whether something is a deprivation of liberty. And I think it's a good tool clinically for people in the ward who might feel ambiguous about it, because it can direct us out of situations through quite robustly developed algorithms. So it's something that's very easy to use. So in summary, I think we've all found over time DoLS are complex. I think really the change to the law is welcome, but it does present new challenges. And if it's easier to refer to create a deprivation of liberty as defined in the scheme, and we can make those decisions, if we start, are we just going to move the bulge from local authority to the coroner's court? So these are all things that need to be considered. Really, engagement between health and social care, I believe, is critical. And this is a good example of how we can work in a collegiate fashion, work together, and really develop clear and locally engaging and collaborative policies to support us, and think about deciding right as a tool to help you at the coalface if you think that you need something to help. Thank you for your time.